rise.
Thanks very much.
Appeal in the matter of Dune Group Ltd and others, and VISA Europe and others, Part
My Lords, can I start with my reply on ground 1A? That's the post-interchange fee regulation counterfactuals. Just by way of introduction, the impact of the card scheme's arguments, if they succeed under this ground, is that behaviour, setting of a MIF, in which they have been engaged for a number of years, and which has been found to be in breach of Article 101 by the highest courts in the UK and the EU, and is therefore been found to be anti-competitive, that behaviour is allowed to continue in a slightly different form, but having exactly the same anti-competitive effect because of the introduction of a piece of European legislation, the Interchange Fee Regulation. That is despite the fact that this legislation was expressly provided to be without prejudice to the application of competition law, recital 14, which Mr. Rabinowitz took you to yesterday, and despite the fact that this legislation simply sets caps for interchange fees based on what is known as the merchant indifference test, that is, at levels which are stated not to be excessive and to reflect benefits to consumers. That's recital 20, which Mr. Rabinowitz took you to. That's a justification which might be relevant to an Article 101.3 analysis, but in our submission it's not relevant under an Article 101 analysis. We say fundamentally that the interchange fee regulation did not lead to any relevant factual change in circumstances, which meant that the conclusions on the law reached by the Supreme Court and the Court of Appeal in Sainsbury's on the application of Article 101.1 no longer applied to the operation of the default MIF rule after the regulation came into force. And I'll explain why. The default rule was applied by the schemes before the regulation came into force and continues to be applied by them today. The Court of Appeal and the Supreme Court found that that default MIF rule was anti-competitive under Article 101.1 because it had the effect of restricting competition on the acquiring market. The acquiring market being the only relevant market for the purposes of assessing anti-competitive effects. In reaching that conclusion, the Court of Appeal held that the analytical exercise which it should carry out, or the methodology which it should employ in order to assess whether the default MIF rule had such effects on the inquiring market, was to compare competition which took place on the acquiring market with the default MIF rule in place, the actual, with competition which would take place in a hypothetical counterfactual. That counterfactual being a hypothetical world in which the measuring question, the default MIF, has been removed, but a settlement at par rule exists. It held that it was bound to take this approach to employ this particular methodology as a matter of law. The question for the tribunal below was whether, as I have indicated, as a result of the interchange fee regulation coming into force, there's been a material change of circumstances, which means that this methodology, which applied as a matter of law, no longer applies. And we say no such change has taken place, and the tribunal erred in law in finding otherwise. And I'd like to address in reply Mr. Cook's 5 propositions that he made yesterday afternoon, which mirrored and summarised the arguments previously made by Mr. Rabinowitz for VISA. And I'd like to go back first to the Court of Appeal judgment in Sainsbury's, which Mr. Cook took you to when making his 5 propositions. And I'll also be taking you to the Court of Justice judgment, which he also referred to in making those propositions. And if we can start with the Court of Appeal judgment, which is at Authorities Bundle 3, tab 12. And if I could ask you to turn in that tab to page 1033, paragraph 126 of the judgment, where you've been to before, and I believe Mr. Cook took you to it yesterday, but in any event, you've certainly been taken to it before. And you'll see that in paragraph 126, the Court of Appeal sets out what the General Court said in paragraph 111 in carte bancaire. In my submission, that is the first step that one takes when analysing the competitive effects under Article 101. It is the first step in the methodology, and the first step is to remove the measures in question. So you talk about looking at the competitive situation in the absence of the measures in question. So that's the first step. Paragraph 127 over the page, I'm not going to read these paragraphs out because you've been read through them and seen them a number of times, but paragraph 127 makes it clear that the measures in question are the rules which set the default MIF. That's uncontroversial. So that first step in the analysis, in the methodology, is akin to Mr. Cook's first proposition. First, you have to remove the measure in question. We agree. That's the first step. But then we move on to the second step in the methodology. And that is hinted at in paragraph 128 of the Court of Appeal's judgment, there on page 1034. At paragraph 128, there's reference to the fact that Ms. Rose, for VISA, argued there has to be a rule as to settlement. And the Court of Appeal says, well, it's not true. That's true, but it is not true that such a rule has to include a MIF. So that point, the second step we say in the analysis, is developed later in the Court of Appeal's analysis of the CJEU judgment, the Court of Justice judgment. And if you can go to that on page 1038 of the bundle in the Court of Appeal's judgment, you'll see the heading at the top of that page, the significance of the Court of Justice, the CJEU's decision. If I can ask you to look at paragraph 147, the Court of Appeal says, in analysing the Court of Justice decision, it's first necessary to understand the error of law that is identified in the General Court's decision. The CJU's main reasoning about the counterfactual analysis began in paragraph 161. There, the Court of Justice recorded the argument that in assessing a restrictive effect on competition, the Commission should have considered what the actual counterfactual hypothesis would have been in the absence of the MIF, and it referred to this established line of authority to the effect that counterfactual competition should be assessed within the actual context in which it would occur in the absence of the agreement in dispute. And then if I can ask you to look to paragraph 150 of the Court of Appeal's judgment, and this is crucial in my submission. It's crucial here what the Court of Appeal says about what the Court of Justice said. The Court of Appeal says that the Court of Justice held that the ancillary restraint counterfactual that the General Court had justified was appropriate for the primary Article 101 analysis, 101 analysis. The General Court and the Commission have been entitled to conclude that the possibility of issuers holding up acquirers who were bound by the Honourable Cards Rule could only in effect be solved by a scheme law prohibiting ex post pricing. Such a rule was less restrictive of competition than MasterCard's existing MIF solution. That led the CJEU to conclude in paragraph 173 that the ex post pricing prohibition could be regarded as a counterfactual hypothesis that was not only economically viable in the context of the MasterCard system, but also plausible or indeed likely, given that there is nothing in the General Court's judgment to suggest, and it's common ground, that MasterCard would have preferred to let its system collapse rather than adopt that solution. Now, what did the Court of Justice mean when it talked about the counterfactual hypothesis having to be not only economically viable, but also plausible or indeed likely. And in order to find the answer to that question, we need to go back to the Court of Justice judgment, which the Court of Appeal was there considering. And the Court of Justice judgment, if you could put the Court of Appeal judgment to one side and take out the Court of Justice judgment, which I believe now is found in Authorities Bundle 1B. And it's behind tab 5 in that bundle. And if I can take you back to the paragraphs to which Mr. Cook referred to support his second proposition. So if we can start at page 372 of the bundle and start with paragraph 165. And this sets out the general test that has been set out in a number of previous cases of the European Court. When appraising the effects of coordination, it is necessary to take into consideration the actual context in which the relevant coordination arrangements are situated, particularly the economic and legal consequences in which the undertakings concerned operate, the nature of the goods or services affected, as well as the real conditions of the functioning and the structure of the market or markets in question. Of course, I stress again, the market in question, the relevant market for the purposes of the effects analysis, is the acquiring market. Then, what follows in paragraphs 166 and 167, I say, is extremely important. And I would like to take a little time to break those down and to say where I say Mr. Cook went wrong in his analysis of those paragraphs. Paragraph 166. It follows from the scenario, from this, that the scenario envisaged on the basis of the hypothesis that the coordination arrangements in question are absent must be realistic. From that perspective, it is permissible, where appropriate, and I'd ask you to underline where appropriate, to take account of the likely developments that would occur on the market in the absence of those arrangements. So yes, one needs to take account of the likely developments that occur on the market in the absence of the measures, but it has to be an appropriate, it has to be appropriate to take them into account. And that's developed a little further in my submission in what is said in 167, when the Court of Justice turned to the problems that it saw with the General Court's judgment below. And what it says is, in the present case, however, the General Court did not in any way address the likelihood or even plausibility of the prohibition of ex post pricing if there were no MIF in the context of its analysis of the restrictive effects of those fees. So it says, well, the General Court did not consider the likelihood or plausibility of such a rule, a settlement at par rule, in the absence of the measures. In particular, and this is the really crucial bit, it did not, as required by the case law set out in the present judgment, address the issue as to how the issuing banks could be encouraged, in the absence of MIF, multilateral interchange fees, to refrain from demanding fees for the settlement of bank card transactions, to refrain from demanding fees. The issue that the Court of Justice says should have been considered by the General Court, but was not, is the issue of how issuing banks could be encouraged, in the absence of the relevant measures, to refrain from demanding fees for the settlement of bank transactions. And this point comes up again in paragraphs 172 and 173 on the opposite page, page 373. In paragraph 172, I won't read it out, but the Court of Justice sets out there and considers the network rule that was proffered or presented as part of the General Court's analysis of ancillary restraint.
Sorry, which paragraph?
172.
172, thank you.
And it says there in paragraphs 95 and 96 of the judgment under appeal, those are the sections of the judgment that dealt with ancillary restraint. The General Court correctly considers that the Commission was fully entitled to conclude that there was an alternative solution of a rule that imposes a prohibition on ex post pricing. So that's where the rule is set out, and it was considered in the context of the General Court's analysis of ancillary restraint. Then in paragraph 73, and it is this paragraph that Mr. Cook focused on yesterday, but I need you to ask you again to focus on what it says. Reading it in light of what has been said in paragraph 167. In paragraph 173, it follows from this that, as is evident from 94 to 96 of the judgment under appeal, the only other option presenting itself as at first instance as enabling the MasterCard system to operate without multilateral interchange fees was in fact the hypothesis of a system operating solely on the basis of a prohibition of ex post pricing. So it was the only option, but it was the only option that enabled the system to operate without those fees. And it's for that reason, in those circumstances, that prohibition may be regarded as a counterfactual hypothesis that is not only economically viable in the context of the MasterCard system, but also plausible or indeed likely. It's plausible or indeed likely because, given there's nothing in the judgment under appeal to suggest, and it's common ground, that it was not in any way claimed before the General Court that MasterCard preferred to let its system collapse rather than adopt the other solution, that is to say, the prohibition of ex post pricing. So, the ex post pricing prohibition, or a settlement of par rule, is the only option that can ensure the system operates without a MIF. As was said in 167, paragraph 167, it is a rule which enables the schemes to operate without a MIF, which, quotes, encourages, in the absence of the MIF, the issuing banks to refrain from demanding fees for the settlement of bank transactions. It's clear, as the Court of Justice said in paragraph 173, that that rule is the only rule that can achieve that aim, serve that purpose. And such rule is not only economically viable, in that it is economically possible to put in place, it's also plausible or likely, because MasterCard would accept such a rule rather than let its system collapse. Now, Mr. Cook's third proposition yesterday that he made on the basis of paragraph 173, and this was an argument that was also relied upon by Mr. Rabinovitz, was that a rule imposing a prohibition on ex post pricing, or a settlement of par rule, was, yes, the only option available at the time. As he put it, it was the only alternative on the table. And he took your lordships to paragraph 173 of the Court of Justice's judgment in order to support that proposition. But what he failed to recognise, and what he failed to draw your lordship's attention to, was that it wasn't just the only option available. The Court of Justice held that it was the only option that was able to enable the MasterCard system to operate without a MIF. Or, as it had put in paragraph 167 of its judgment, it was the only option that was able to address the issue of how issuing banks could be encouraged in the absence of the MIF to refrain from demanding fees for the settlement of bank transactions. Now, my submission is that the Court of Justice hereby recognises that in order to achieve its aim, in order to do its job properly, as I explained in opening, a counterfactual hypothesis has to ensure that competition can take place in the hypothetical world. It has to ensure that in that hypothetical world, conditions are such that there can be competition on price in the relevant market, in the acquiring market in this case.
Now, how do you get that from these passages?
Because, my lord, it says, the Court of Justice says, we need in place a rule for the settlement, we need in place a rule which encourages the banks to refrain from demanding fees, which ensures that the MasterCard system can operate without a MIF.
But isn't that entirely consistent with Mr. Cook's hypothesis? Because if you can't restrain that, then you will end up with the collapse of the system.
Yes, my lord, and that's why it's a plausible counterfactual. But the prior question is, what does the counterfactual have to do? It has to ensure that the system can operate without the measures in question, without the restriction on competition.
It does, because otherwise it will collapse. And
My lord, yes.
MasterCard isn't
My
likely
lord,
to
yes.
choose
But
that
you
option.
don't, in that situation, say, it says here is the option that is available and plausible. And it's an option that enables it to operate without the measures in question, without the restriction on competition, without demanding fees for the settlement of bank transactions. And if I may, I'll go on to explain to you why I say that other options which don't do that, but nevertheless allow the system to operate, but allow the system to operate, but also allow issuing banks to demand fees for the settlement of bank transactions as per paragraph 167.
Isn't it looking, I mean, your analysis may be right, but certainly my reading of 167 is that what they're talking about is the prohibition on ex post pricing. And what
Yes.
they're saying is, well, if you've got a MIF, then you've set a default MIF under
Yes.
the rules. Then the rules have established in advance what the issuing bank can charge.
Yes,
If you don't have a MIF, so in the absence of a MIF, what they're then asking themselves is, how do we stop banks, issuing banks, where there's an honour all cards rule, so they're basically, they can hold up
yes,
and say stand and deliver,
yes,
charging after the event huge fees
yes.
for processing transactions.
Well, my lord, that it's
That-
not.
So it's looking at the position post
Yes,
transaction.
absolutely, my lord. And it says that can be done by using the prohibition on ex post pricing rule.
Yeah.
And that is and I'll go on to develop the
So that's
point.
what they're focusing
But
on. They're
yes,
not looking at
that
the
is-
MIF as such.
Yes. You take away the MIF
They're
because you've got
assuming-
rid of the measure in question. And then you say, well, how can the system operate nevertheless? Because it's got to be actual, it's got to be a reasonable, feasible.
Yeah.
And this option is available, the option of settlement at par. That option, and I'll develop this point, but just by way of summarising what I'm going to say, that option was available to the schemes before the Interchange Fee Regulation came into place. It continues to be available to them after it came into place.
But the argument you're facing is that then it was the only option because the alternative was collapse. Now it's not the only option because the alternative is setting fees at the IFR level.
Well, no, my lord, it was the only option that dealt with the hold-up problem and that did not
Yes, but
lead to competition problems, because the ancillary restraint argument in which this option was first put forward, it was put forward as saying,
it was objectively necessary.
no, my lord, well, yes, my lord, because the other option for preventing collapse, and this was the ancillary restraint argument, available to the schemes before the regulation came into place, was the default MIF settlement rule. They argued we have to have the default MIF settlement rule, because otherwise our scheme will collapse. And they said, no, that's not the only option available to you.
You
The
can
other
have-
option
you
is
can
the
have
settlement of par
settlement
rule.
of par, yes.
Now they say, we'll replace the default MIF rule with arrangements, and we'll come to what that means, but with arrangements that do exactly the same as the default MIF rule. And I say, no, that's still not, those are not. Those are options available to you, just as before the the IFR regulation, just as before the IFR regulation came into force. The default MIF option was available to you. Those options are now available to you, but the ex post prohibition on pricing, the settlement at par rule, is also still an option available to you. And that option is the option you should use in the counterfactual, because it is an option which is available to you. It is economically viable, it is feasible, and it is, the third one, likely.
It's the likely.
Because, yes, likely, because the likely is to be judged when you say to MasterCard, if we just take your default MIF rule away and say to you, you can use the default MIF rule, or you can have this other option, which is prohibition on ex post pricing or settlement at par, is it likely you'd go for the latter? Yes, it is likely you would go for the latter, because if you did not go for the latter, in the absence of your rule, your scheme would collapse.
But that's
You
no
may
longer-
prefer to go with other options.
That ignores the fact that they now have this other option.
My lord, yes, but the other option does not get rid of, does not address the issue as to how you could encourage issuing banks to refrain from demanding fees.
But the reason on the face of it why they were worried about that was that if issuing banks could demand
Yes.
fees on an untrammeled basis, the
Yes.
scheme would collapse.
Well, my lord, that's why they may be worried about it, the schemes. But what I'm saying is, why is the Court of Justice, in applying the competition rules, looking at this alternative option?
Because
It's
if MasterCard has the choice of the scheme collapsing as the only alternative,
Yes,
he's going to opt for the settlement of par
Yes.
rule.
Well, my-
Therefore, the settlement of par rule is likely.
yes. Well, let's look at, it's likely in that if you give these two options, as I've said to my Lord Justice Nugee, if you give these two options to the schemes, take away the measures in question, allow the scheme to collapse, or take away the measures in question, put in place a prohibition on ex post pricing, it's likely they'd choose the latter. If they were given the options of take away, if you were, say, let's step back from the situation of interchange fees. If the Court of Justice has found that the apocryphal widget manufacturers had entered into a price fixing agreement which had been in place for decades, they all knew that there was this agreement in place. They all conducted themselves in line with that agreement. The courts, because it's the courts and the regulators in enforcing competition law, say no, you can no longer have that agreement in place because it's anti-competitive. Are you really saying that the court would say it's fine in that situation for them to take away the agreement, but to replace it in some other way, with some other arrangements, even on this example, unspoken arrangements, which have exactly the same anti-competitive effects, and say, therefore, and this is the crux, therefore, I will compare the situation with the agreement in place, this price fixing agreement, with the option of carrying on the anti-competitive pricing without the explicit agreement, and find, therefore, that the agreement does not have anti-competitive effects.
Might this anyway be an object restriction in the particular scenario you're talking about?
Well, my lord, it might, but that leads on to the question about, at the other end of the spectrum, there may be situations where you take away the measures in question, you look at what might happen or what options were available, and price competition does kick in. The problem, we say in this case, is when you look at effects in the actual context in which they occur, and you'll recall carte bancaire paragraphs 126, I've probably got that wrong, but carte bancaire says that when looking at the effects of an agreement, the actual context in which they occur, the economic and factual context, we have a context in these markets where there has been a history of collusive anti-competitive arrangements which have been found by the Supreme Court to be anti-competitive, a history of collusive anti-competitive arrangements between issuers, acquirers, and the scheme to set interchange fees. We have two, the ongoing operation of a set of collectively agreed scheme rules, including an honour all cards rule. And we have three, the common commercial incentives of issuers, acquirers, and the scheme, which I explained in opening, which lead almost inevitably to the imposition of interchange fees. In other market situations, with other factual and economic context, that might not be the almost inevitable result. It may be that the effects would be different, that taking away the restrictive measure does allow competition to develop. The problem is that in this situation, against the background of the three elements I've just outlined, there is no competition, there is no competitive process under which merchants would agree to pay interchange fees for settling transactions on the acquiring market.
Your problem is, the argument you're facing is, that's not because there's a default MIF rule. It's the default MIF rule, which everybody agrees is, for the purposes of today, the measures in question. It's that which you're attacking as being unlawful. And the argument you're facing is, it's not the default MIF rule which causes interchange fees to be charged at the IFR level, because it would happen anyway, with or without the default MIF rule.
My lord,
Therefore, you can't just say the default MIF rule is within Article 1011, because we know you have to go through the counterfactual analysis to decide what the effect of the rule is.
Well, my lord, with the greatest respect, in that regard, which is why I stressed at the beginning, that what we're doing here is looking at what the appropriate methodology is for determining whether the default MIF rule is anti-competitive. We are not deciding whether the hypothetical arrangements which the schemes might enter into, say they will enter into in the absence of the MIF, which are not the subject of analysis. We are not considering whether or not they breach 1011.
No, you've made that
We're
clear.
considering whether the default MIF rule breaches 1011. And I'm saying in that situation, as the Court of Justice recognised, it is not the correct approach to put in place a counterfactual which leads to which one has exactly the same effects on competition as the measures at issue, and which leads you, on the scheme's arguments, to the inevitable result that the continuation of these rules is suddenly rendered not anti-competitive because of the introduction of this regulation. When I say the proper analytical exercise is to look at the absence of the measures in question, two, what might be necessary to ensure that nevertheless there can be settlement of payments over the system. That second element, which is what was considered by the Court of Justice in the paragraphs I've just taken you to, can be done by way of a settlement at par rule. So that's all you need.
So just take it a stage further. We see from carte bancaire that you look at what would have happened if the measure had not been there.
Yes.
As I understand it, you're saying you don't just do that, you apply some further test.
Well,
Because if you just look at what would have happened if the measure hadn't been there, you might find something that is unacceptable. Now, I would understand that if you were saying the alternative infringed competition law, but that's not a question for today. So if we have another test, which is not does the counterfactual breach competition law, what is the other test?
the other test is that because you start with taking away the measures, you may need to put in place something that enables the arrangements to work. But what you put in place should not be more than is necessary to ensure the arrangements work, and certainly lead to the same anti-competitive effects as the measures you're taking out, because you need to look at competition on the acquiring market. And as I've said, absent a default MIF rule, merchants wouldn't pay interchange fees for settling transactions. So you can't just take the measures away, as you might in a case where you're fixing the price for a particular product,
Doesn't your
and the
argument
product
end
will
up-
be.
Doesn't your argument have the circularity that I was putting to Mr. Newey yesterday, that this whole exercise is to establish whether the default MIF rule is restrictive of is anti-competitive, is restrictive of competition, and the reason for having a counterfactual is to look to see what would have happened in a world which didn't have that default MIF rule. But you don't just assume that it is anti-competitive and therefore inevitably whatever the alternative arrangement is going to demonstrate it is anti-competitive, because the whole point of the counterfactual is to establish whether it is anti-competitive. You might find, and this is the point that's made against you, is that the rule, the default MIF rule in the scheme rules was the measure in question. It was anti-competitive. If you take that away, you've cured the particular evil, but you're then left with it asking the question: well, what would have happened in the real world without that rule? And what's said against you is what would have happened in the real world because of the IFR is something different from what was being considered by the Court of Appeal and the Supreme Court. And that's the problem that I'm grappling with, to be honest, is you may be right. You may be right and you may succeed at trial, but the question for us is, was this so demonstrably wrong that they shouldn't even be able to argue it?
Well, my lord,
that's the question.
I think the first point, the question is whether it can be said that anything changed when the IFR was
If you're right about
introduced.
that, then you're entitled to summary judgment. But
Yes, and that is the important thing to keep in mind. The question is whether there was a change in relevant factual circumstances, and which meant that the finding of law made by the Supreme Court was no longer held good, and which was based on the Court of Justice's judgment. And before I go to examine that point, as to whether there was any change in factual circumstances, I need to make the following point. That, as I hope I've illustrated by showing you the step-by-step reasoning in the Court of Justice's judgment, a counterfactual is not just what would happen if the measures in question are taken away. In the normal course of things, it's also has to make sure that the process of competition on the acquiring market here can operate, that a process of competition can operate. And usually, in another type of case, just taking away an anti-competitive restriction will allow the process of competition to operate. Here it does not, because of the hold-up problem, among other things.
well, that's right, but the hold-up problem is caused by the honour all cards rule.
It's not just, my lord, it's not just caused by the honour all cards rule. If one looks at the footnotes to Dr. Niels's report and the explanation in Dr. Niels's report, it operates as a result of the three factors I've just outlined. The history of anti-competitive behaviour, number one. The set of collectively agreed scheme rules, including the honour all cards rule, number two. And three, the common commercial incentives of the issuers, acquirers and the schemes, number three. Those lead to this, what we've called the anti-competitive effects, what the schemes have labelled as the hold-up problem. But what that means is that in this acquiring market, competition does not take place in the absence of the measures in question unless you can put in place a rule about settling transactions. And the necessity of that rule for settling transactions is not just to enable the scheme to operate, but to enable the scheme to operate in a way that enables price competition to emerge. And then you consider whether, comparing that counterfactual with the actual, price competition would emerge, whether the the measures in question have anti-competitive effects. Now, a question your lordships put, I think, to Mr. Rabinovitz yesterday is, isn't the problem with that way of approaching the counterfactual that it inevitably leads to the conclusion that there are anti-competitive effects or a restriction? And there are 2 points that I want to make in response to that. It may be that in these particular circumstances, that is the almost inevitable result. And it may be that when you apply this correct approach to a counterfactual, it does lead to the conclusion that there are restrictive effects on competition in the acquiring market. You will have seen that that is exactly the process the Court of Appeal and the Supreme Court in this case went through and the conclusion they reached. So yes, my first point is it may lead to that conclusion. In a different factual situation and with a different measures in issue, it may lead to a different result applying this conceptual approach. The second point, however, if I could just make my second point, is that if you actually apply either of the scheme's counterfactuals, they inevitably lead to the result that you will continue to have the same anti-competitive effects on the acquiring market as a matter of inevitability on their evidence. So that's my second point on that point.
What I wrote down, this may not be exact, is you need a settlement rule for 2 reasons, not just to avoid the scheme collapsing, but also to ensure, to enable competition to take place. But if you put in place a counterfactual which enables competition to take place, you are by definition assuming that competition is not taking place with the default, the measure in question.
Well, yes.
And if you take away the measure in question and put something in which enables more competition to take place, then by definition, what you've taken away is going to be anti-competitive because you've written that into your counterfactual.
And I think, my lord, there, if I may say so with respect, you are taking the conclusions that might be reached on the facts of this case and saying that as a result, that leads to the conceptual approach being wrong. As I just said to my lord, the Chancellor, it may be that when you apply this conceptual approach to these facts, it leads to that inevitable result. But that's not necessarily the case.
I'm afraid I'm still not clear what the conceptual approach is, in the sense that you don't just find out what is likely to have happened, and you don't go beyond that and ask yourself whether what is likely to have happened would infringe competition law. You apply some third test.
Well, my lord,
I'm afraid I'm not clear what that test is.
well, perhaps the easiest way of breaking it down is by looking at paragraph 173 of the Court of Justice's judgment.
I mean, I think what you're saying is that it's not just a question of whether it was likely, because if you didn't have settlement at par, the schemes would collapse. But it's also a question of having to have settlement at par, because otherwise you perpetuate anti-competitive conduct.
There's that.
I think what I wrote down, you said, in the acquiring market, competition will not take place in the absence of the measures in question unless you have settlement at par.
That's
or
right.
Prohibition on ex post fact pricing.
Yes, my lord, that's absolutely the case. But also, perhaps in response to my
Just
lord
before
Justice
you go to
Newey's,
173,
Yeah.
Like my lord, I don't really understand where you get this sort of gloss on the test.
well, this is where I want to take you to 173.
just before you do, I mean, 173 will be tied to the facts of this case, but what is the general proposition? What is the test you are in principle applying when you found out what's likely and you've decided that it's not contrary to competition law? You then apply some third test. So what is it?
You don't start with what might be likely. What you start with in the counterfactual is you take away the measure. Then you decide, is that enough? In most cases, it might be enough to then look at what the effects of the alleged anti-competitive agreement are. Step one, you take away the measure. Here, in these circumstances of this case, the Court of Justice does accept that it's taking away the measure without anything would lead to the scheme's collapse. So they say in paragraph 173, take away the measure, and then you need to have an option, and this is paragraph 173, which enables the MasterCard system to operate without the measure in place. That's the first 3 lines of 173. You then consider, and it's only at this last stage of the reasoning, whether that option is plausible or likely and economically viable. So 1, you take away the measure. 2, you need to ensure that the system can still operate. 3, you look at whether the option that you've identified to enable the system to operate is economically viable, plausible or likely.
I mean, I'm not sure that gives me a test, but suppose we approach it in that way.
It's
So
not
we
necessarily
take-
a test that can apply everywhere, because in most cases it's not the case. You need to get to step 2.
So take our situation now. We take away the default MIF rule. Then we have to ask ourselves whether something more needs to be done for the system to operate.
Yes.
Answer no, because the system will survive as it is with the IFR in place.
I mean, that is exactly what Mr. Cook's proposed counterfactual is.
Well-
You take away the MIF rule and you put nothing
Yes.
in its place.
Right. Well, in that case, my lord, this is the steps in the reasoning. You take away the relevant measure. Then you say now, post-IFR counterfactual, post-introduction of the IFR, I need to find an option to ensure that the scheme can operate. There are a number of options available to me. One of them continues to be the default MIF the settlement at par rule. One of them is to enter into bilateral arrangements or put in place a rule that puts in place a cap at the IFR levels. That might enable the system to operate, but it does not enable the system to operate without, in effect, the same problem arising, without a MIF.
That
That's
assumes
the
there's-
critical question as to whether it is the same problem arising.
Well, my lord,
What's said against you,
yes,
and the issue for us is it sufficiently arguable to, as it were, be
Yes.
let through the net, is that because there is no rule as to, taking Mr. Cook's, as it were, cleaner counterfactual, which says there's no rule and people just do what they like.
yes,
What they will end up doing is fixing bilaterally the
yes.
interchange fee at the level of the IFR. I mean, that's essentially what he says, what his witness says is likely to happen.
Yes.
And the question for us there is, because I think it's always been accepted that merely charging for something, here charging a MIF per se, is not anti-competitive. The charging of the MIF per se.
Yes.
It's not, there's nothing, the evil is not in the MIF, it's in the rule that imposed a default MIF.
Yes.
So what's said against you is, well, here you may end up with MIFs and people paying, as it were, more money, but it's not anti-competitive.
And again, I think that goes back to the point, my lord, that you cannot, in looking at the other options that were the schemes say are available, ignore the fact that those options only exist because of the history of anti-competitive behaviour. Because of, as I've said, 1, the history of collusive arrangements, 2, the scheme, the collectively agreed scheme rules. So they're not operating totally unilaterally. They're operating in the context of collective arrangements. And because of the commercial incentives that are set up across this scheme. So it's a question of when there are a number of options available at the second step of this reasoning, and the schemes quite understandably say we want to take an option that will basically perpetuate the problem, continue the problem in place. You say that is change things fundamentally to the extent that the options that was available and continues to be available, the settlement at par rule option, is not the option that should be employed in the counterfactual.
So, what's the test? You've got at your stage one, you take away the measure. Stage two, you find out what options there would be counterfactually that would allow the scheme to survive. And you find there are two, one with the IFR and one with settlement at par. So what principle do you apply in choosing between them? And where do you find that in the authority?
This is, well, first of all, the very purpose of rules, the very purpose and fundamental aim of rules prohibiting anti-competitive effect, anti-competitive conduct is to enable competition to take place. So if you twist the rules, the conceptual approach, to perpetuate anti-competitive effects, that is fundamentally contrary to the purpose of those rules. And we say that strong purposive approach colours the judgment of the Court of Justice and makes it clear that what the Court of Justice there was doing by talking about refraining from demanding fees and operating without a MIF is because it's in its DNA for the Court of Justice, this competition court, to approach matters like that. Against that background, that possibly unspoken assumption that you do not use the rules or the conceptual approaches developed under the rules in order to defeat the object of the
Clearly, if you're writing your ground 1B, in other words, if these the UILM order, it's called, and all the bilateral arrangements of Mr. Cook's clients are in fact still agreements on concerted practices, you're absolutely right. I mean, what's happening is you're replacing one anti-competitive course of conduct by a collusive alternative anti-competitive course of conduct. But what's said against you is that this isn't an agreement or concerted practice, that this is just what would happen in the real world if people look after their own interests financially, and that's we would refer to the Woodpole position.
Yes. Well, my lord, yes, and I'll come to ground 1B, but in a nutshell, my point is that when you're looking at a counterfactual, the counterfactual situation, you don't have to prove that it breaches 1011, but you do need to, in any event, the arrangements proposed by the schemes are not purely unilateral arrangements at all. They are either a rule that's collectively agreed, VISA's UIFM, even though the rule itself may not contain an instruction to price at a particular level. The rule says, against the background of 20 years of pricing at a particular level, you can, if you want, price at this level. That's VISA's UIFM, it's a collectively agreed rule. And in the case of MasterCard's bilaterals, again, against the background of 20 years of a collusive arrangement, you say to the issuers and acquirers, we're not going to tell you what to do, but you can enter into these sort of agreements if you want. And they are collective arrangements between acquirers and issuers, which operate alongside collective arrangements, the scheme rules between issuers, acquirers, and the schemes, against the background of 20 years of explicit anti-competitive arrangements. So in those circumstances, and looking at, as I took you to, what the purpose of the broad definitions of agreements and concerted practices, and the purpose of those broad definitions being so as to ensure that parties cannot engage in collusive conduct and simply in a less explicit way, I'm sorry, that's probably not the wording, but I took you to the case law on that. These were collective arrangements. These are collective arrangements, hypothetical collective arrangements that are being proposed by the schemes. You can't analyse them in the absence of their context and their history.
Are we now on ground 1B?
Yes, I
Yeah.
meant very well. Can I be given a moment, just because as a result of that discussion, I may not need to develop these points. And I think I'll just make this point, which I'll try and make as briefly as I can on ground 1A. It's fundamental in my submission that the rule imposing a settlement at par or prohibition on ex post pricing remains an option which is available for schemes. It was an option before the IFR came into force, and it remains an option after the IFR came into force. After the IFR came into force, such a rule is still, as the Court of Justice put it in paragraph 173, not only economically viable, but also plausible or indeed likely. Because it's still the case that given the choice between that option and no such rule, Visa or MasterCard would accept it rather than let its system collapse. There's been therefore, no material change in circumstances as a result of the introduction of the IFR in this regard. This counterfactual still remains applicable. Now, it might be that Visa and MasterCard prefer what they describe as other options. That's their Visa's UIFM and the MasterCard's bilateral arrangements. But my point there, again, and I think this is just putting the same point in a slightly different way, those options do not address the hold-up problem. They simply limit its impact. They allow hold-up, just they allow it up to the level of the IFR caps. And in a way, therefore, they do exactly what the default MIF rule did, and the default MIF rule does. It also allows hold-up to a certain level. Now, for domestic and intra-EEA domestic transactions, that is also the level of the IFR cap. So the schemes proposed post-IFR counterfactuals, we say, are not in fact counterfactuals. What they are simply different arrangements which allow partial hold-up. Before I leave that point, I do also need, and I think I can do this, I hope, very briefly, need to address paragraph 181. This is a slightly different point. Paragraph 181 of the Court of Appeal's judgment that was put to you by Mr. Rabinovitz at the end of his submissions on Monday, at the beginning of his submissions on Tuesday. And you will recall it was suggested to you by Mr. Rabinovitz that what the Court of Appeal said in that paragraph, paragraph 181, was that the Court of Appeal judgment simply turned on its own facts, and at that, on the basis of different evidence, your lordships could find a different counterfactual. That's day 1, page 180, line 23. He said, in this paragraph, the Court of Appeal accepts the possibility of a different counterfactual. That's not actually correct when you look at paragraph 181. If I could just ask you to, I think you may still have open Authorities Bundle 3, tab 12, see what paragraph 181 actually says. It's on page 1045. And you'll see on page 1045, paragraph 181. This is where the Court of Appeal was dealing with a bilaterals counterfactual adopted by the Competition Appeal Tribunal, the CAT. You'll see that from paragraph 180. And then it says, we emphasise we're not holding that no amount of evidence could have made it appropriate to find that even in a no default MIF and a prohibition on ex post pricing counterfactual, bilateral interchange fees would have been agreed. It might have been possible to show the economic background to the MasterCard scheme in question was so different to that being considered by the Commission, the General Court and the Court of Justice, that a different outcome would have occurred in a similar counterfactual world. The evidence relied on by the CAT in those paragraphs, however, comes nowhere near to achieving that objective. So I think, as Mr. Cook fairly accepted in his submissions to your lordships yesterday at day 2, page 177, lines 8 to 17, here what the Court of Appeal was considering was whether the CAT judgment that bilateral agreements would have emerged in a counterfactual of no default MIF and a prohibition on pricing or settlement at par counterfactual. That's what they were considering there. And they were saying that on different evidence we might be able to come to a different conclusion, but they were not applying a different counterfactual or saying that on the evidence you could have had a different
Well, it was whether bilateral fees could have emerged in a no default and settlement at par scenario. So you start with no default MIF and settlement at par, and then ask yourself the question whether they would have been bilateral arrangements.
My lord, exactly that.
Which is what the CAT have decided. And all the Court of Appeal was saying here is that the evidence for the CAT just wasn't good enough.
Yes, exactly, my lord. That's the simple point.
Yeah.
So it doesn't say anything more than that.
I'm sorry, I think it's clear. I'm still not quite clear how that differs from Mr. Cook's counterfactual no default rule and bilateral arrangements emerging.
Well, my lord, I was addressing the point there that Mr. Rabinovich took from paragraph 181, which is that on different facts, the Court of Appeal could have found a different counterfactual. And I say that paragraph 181 does not say that.
It doesn't say that. It says,
There was a
it says if
different-
you have the same counterfactual, different facts might emerge.
Yes. My lord, as I recall, and again I'm not on top of the exact details in front of the CAT, but one of the issues in front of what was held by the CAT in its judgment below was that even in a situation where there was no default rule and a prohibition on ex post pricing, so a prohibition on ex post pricing stops issuing banks saying, settling transactions and then going back to the acquirer and the merchant and saying, I'd like you now to pay an interchange fee. The CAT said that in that situation, where the ex post world is dealt with, banks and these schemes would nevertheless have entered into ex ante bilateral agreements setting up, and he said no, that the evidence did not show that, the Court of Appeal said. So my lord,
Thank you. It's just dealing, this is a section of the Court of Appeal judgment which is dealing with the CAT's handling of the bilateral issue, which was from recollection was pretty unsatisfactory. I can't remember the detail now, but I do remember
yes,
we were quite critical of it. And I was just looking again at 176 and 177, from which it was apparent that exceptionally it was agreed that this court should consider the appeal on a broader High Court basis, because the case had originally been, I think, in the commercial, no, it was in the Chancery Division, I think it was transferred by Ms. Justice Farling to CAT.
yes, my lord, that's right.
So in fact, it was that was a way of dealing with the point about the way in which they dealt with
Yes.
bilaterals.
Well, my lord,
whether it was an appeal on fact or law.
yes, my lord, there were 2 points. One, the unsatisfactory nature of the evidence, but 2, the bilaterals counterfactual that was, the bilaterals that were considered by the CAT were different from those that form MasterCard's bilaterals counterfactual. Because as Mr. Cook accepted, and I gave you the reference to his submissions yesterday, what was being considered by the CAT was the different situation that I explained to my Lord Justice Nugee.
Yes.
So, I'm just looking to see whether there's anything else I need to say about ground 1B. And I think maybe if I could just briefly take your lordships to the CAT's judgment that's under appeal, which is in core bundle 5. Sorry, core bundle tab 5. And the particular paragraph is at page 157. Page 157, my lord. Paragraph 41 of the CAT's judgment. And there the tribunal says, we think it's clear that the bilateral's counterfactual would not involve any restriction of competition since, under that scenario, the interchange fee is not determined by a collective arrangement. That's the MasterCard counterfactual. Insofar as Ms. Smith sought to argue on behalf of the claimants that the UIFM counterfactual was restriction because it depended on a common scheme rule, we don't accept that submission, and therefore they hold that the restriction they carry on in the rest of that paragraph. The point we make on this is that the tribunal erred in making those findings, and I emphasise first that what should be uncontroversial, that the tribunal does not have to find that arrangements in a counterfactual breach Article 1011. The counterfactual is a methodology for working out whether the arrangements in the actual breach 1011. So that's the starting point. But in any event, we say that the tribunal erred because, as I've already explained to your lordships, each of the proposed arrangements, those proposed by VISA and MasterCard, did involve agreements or concerted practices in quotation marks, as those concepts are understood for the purposes of Article 101. Particularly when they're viewed in the context of the other collective scheme rules alongside which they operate, which are clearly collective arrangements, and with which they are fundamentally intermeshed. And secondly, when they are viewed in the context of their history. When you look at that, you can see that these are collusive collective arrangements that clearly restrict competition on the acquiring market. We say in paragraph 61 of our skeleton, they would perpetuate the collusive charges that are in the actual subject to an express agreement. So I made the point about moving from an express agreement to a less express agreement, to arrangements that simply reproduce the effects of that express agreement. So,
I'm sorry, Mr. Smith, I haven't understood. You've made it a number of times. The point you've made that there's 20 years history of this. I could understand a submission that said people have been acting collusively for years and years, and although ostensibly they're now going to act independently, the reality of what's going on is they're still going to act collusively. What my Lord the Chancellor referred to yesterday as a nod and a wink basis. We all know that this is what we all want each other to do, and we're going to agree to do it sub silentio. That's really a sort of sham or illusory type argument, but that's a factual argument.
Yeah.
But
You're missing a horse and groom and had a drink together, and look what happened as a consequence, which I think was actually one of the cases from recollection.
yes.
Yes,
Time
and
manufacturers
so I understand that
compensate.
sort of submission,
Yes.
but that's not the case you're facing at this stage. The case you're facing at this stage is we're not going to get together in the pub and decide what to do. We're all going to go away and decide what to do. But because, and this is your own point, because of the competitive pressures of these particular markets, in particular the honour all cards rule, plus the fact there's no incentive to do anything else, they will all independently do the same thing. Now,
No, my lord, that's the... Sorry, I interrupted you.
now, if that's right, that again is a factual question.
Yes, no, my lord, that's...
And at the moment, I'm having difficulty in seeing why factual questions are not questions for trial.
No, my lord, this is... Okay, dealing with this step by step. The first point is that this is not a situation where the rule is removed and suddenly everyone is acting independently. It certainly is not, because as I said, there has been a history of what has been found by the Supreme Court to be an anti-competitive price fixing agreement. And that has been in place for decades. So that it is, the first step is there is the situation that your Lordship just outlined to me. Then, when you take it away, you can't ignore the effect of the existence of that, or the ongoing effect of the existence of that agreement. That's also, it's not just that it's taken away and everyone starts operating totally independently. As I said, there are the three elements. There's the history, there's the fact that they are continuing to operate collectively under the scheme rules, which include the HACR, but not just the HACR. There is an ongoing collective arrangements under which they are operating. And then third, there's the incentives. But there are those three elements, all of which need to be considered in determining whether just taking away the explicit arrangement, but leaving
Commercial
in place.
incentives in themselves wouldn't be sufficient.
No, and I don't rely on them in themselves, on their own. I rely, as I said, on the
quite
3 points.
understand
Yes.
your point, insofar as it essentially says, well, look, this hold-up problem, on these counterfactuals, it hasn't gone away. The hold-up problem hasn't gone away because of the honour all cards rule, and that it may be that either in this case or another case, your clients will or other claimants will be able to establish that the honour all cards rule is itself anti-competitive, because what is clear is if they didn't have to accept all the cards, then there would be nothing like the same incentive to the issuers to charge whatever they could. They probably all be falling over each other not to charge interchange fees at all.
Well, my lord, the first point on that, and I'll come back to the point about the competitive pressures, and I'll be reminded if I forget to come back to the point. But the point on the honour all cards rule is that we do not have to prove that it is in itself anti-competitive, and for the purposes of this appeal. So let's assume, for the purposes of argument, that it's not in and of itself. Why we rely upon it simply because of its existence and how it operates. How it operates is that it means that the acquirers and the merchants, more particularly the merchants, cannot engage in bargaining and play off the acquirers against one another because they have to accept all the cards, different cards from different issuers. So it is simply the existence of that rule and what it requires that we rely upon. As to the competitive pressures, I said that's one of the three elements that I rely upon. But it is also important to remember that the competitive incentives do not arise independently. They arise because the issuers, the acquirers and the schemes have got together to set up a collective scheme. So the competitive incentives arise as a result of collective agreements. Now it may be that trying to say that this is everyone acting wholly independently is just not right in light of those three elements, including the incentives, which are not simply arising independently. They are a product of the scheme agreements.
Well, what you're really saying is you can't. I think is in view of the 20-year history of collusive arrangements, you can't, as it were, break free from participating in collusive arrangements, other than by abandoning MIFs altogether. That's what it comes to.
Or by, well, of course, no.
Or by other than by setting MIFs at zero and having a settlement of Parliament.
For the Article 1011 purposes, yes.
Yeah.
It may be that then, and that is what the Court of Appeal and the Supreme Court held. It may be that the schemes are able to say, well, the benefits that arise as a result of these MIFs, then we get onto it. So it's when you express perhaps the implicit concern in your voice about saying you can't have them at all. Remember, we're only dealing 1011 here.
Well, I understand that.
Yeah,
But I mean,
you know
that's
that.
essentially what your argument comes to, saying because there's been a history of collusive arrangements, you can't just say, well, we're not going to have a rule anymore, we're going to let everybody do what they want to do, because the truth is they're not really doing what they want to do, they're following like sheep, as they always have done, they're just going to do what they were told without a rule.
It's not,
Same
well,
thing as
we
they did
say
before.
that, we say that there may not be a rule. First, two things we say. One, we say there may not be a rule, but two, there are still collective arrangements for the reasons I've given and for the reasons I gave in opening. Second point, we say it's not just the history of collusive behaviour, it's the continuing existence of the scheme rules and the pressures which are themselves, the competitive incentives which are themselves a product of the agreements. And this is not a factual argument, it is the argument that you cannot distinguish these arrangements on any relevant facts from those that were held to lead to the result as a matter of law in front of the Supreme Court and the Court of Appeal.
Can I just, before you leave paragraph 41, ask you briefly about the last sentence, paragraph 41, where the tribunal says a rule that enables each issuer independently to determine the level of its interchange fee is not restricted to competition. So we're here looking at the UIFM.
Yes.
One way of working out whether the UIFM is anti-competitive would presumably be to apply a carte bancaire test and say, well, if you took away the rule, how would things be different? So if you took away the UIFM, how would things be different?
You would then assess it against a counterfactual that the Supreme Court and the Court of Appeal has held applies.
Well, that seems to sort of beg the question.
No, my lord, I think
what you're saying is if you take away the UIFM, you have to insert a new rule, which is settlement of parts.
Yes. Well, my lord,
If you simply take away the UIFM,
well, this is the point I made at the beginning. We're not engaging in a counterfactual analysis of the counterfactuals. Because it's not them that are being held to be in breach of Article 1011. Where I say the tribunal goes wrong in that
If they
last...
were in breach of Article 1, I mean, this is the whole point of your ground 1B.
No,
These
my lord, they don't need...
counterfactuals are not, somehow they're not acceptable counterfactuals because
they don't...
they perpetuate the anti-competitive...
My lord, we say they are not acceptable counterfactuals for all the arguments that I've developed under ground 1A.
Yeah.
Where we say the tribunal went wrong in paragraph 41 is essentially it went wrong in finding, if that is how you read paragraph 41, that you've got to establish that the counterfactuals themselves breach Article 1011. You don't. But in any event, in finding that there is no collective arrangement, it was wrong because of the reasons I have developed. And
in a
the
sort of way
tribunal...
that may not matter. If the truth is you do have to judge whether a counterfactual would itself be anti-competitive, it doesn't particularly matter whether it involves a collective arrangement, because if taking away the rule you would be no better off, then it's still all right.
Yes, I think I agree. I'm going to move on, if I may, to the cross appeal and to my ground 2, but would it now be a good time to break if we are having a transcript taken?
Well, how long are you going to be in all? I didn't say...
I'm anticipating that these other arguments are probably not going to lead, I might be wrong, to as many interventions from the bench. If that is the case, I hope, although I can't guarantee, that I'll be finished by lunchtime.
Well, in that case, we will have a 5-minute break.
Thank you, madam.
Back at 5 to 12.
Thank you.
Human rights point. I do enjoy it. Human rights point.
Yep.
Well, it's a long time there was only just on the human rights application. Every single year. Article 6.6.
Good measure.
Actually, it's set judges quite wrong. With so the right to a fair trial only came in kind of human rights act and recognise that at all. Well, we know what Smith will say. The question is how many pages does he spend on it?
Squarely an issue.
Evildoers, absolutely. Rather with facts. Yeah, exactly.
That's why you put your barrier in the way.
I'm so blind. I love this lecture because it's got a bit higher than the other one. It's hard. The papers here.
Just say one, it's just turned down.
Of course.
So let's call class.
Thank you, members. Before I move on to reply to the visa and cross-appeal arguments made by Mr. Rabinovitz, can I just make one very brief point, which is asking your lordships to look at this, the issues under ground one, in a slightly different way, which is as follows. As I said, and I stressed this when I started my reply, the relevant market for the purposes of 1011 is the acquiring market. A settlement at par rule is necessary to enable that market to operate. It's necessary to enable transactions to be made between acquirers and issuers and merchants. Sorry, between acquirers and merchants. Any arrangements over and above a settlement at par rule, such as the default MIF rule, or setting a MIF at a higher level equivalent to the IFR caps. The only arguments given for imposing a positive MIF over and above a settlement at par rule is that such a positive MIF is necessary to ensure the schemes don't collapse because of competition from other schemes. So because of issues that arise in a different market, the inter-schemes market, and the courts have made it absolutely clear that the inter-schemes market, competition and pressures that may result on the inter-systems market, the inter-schemes market, not relevant for the purposes of 1011, unless there is an ancillary restraint argument, which we're told there isn't, or then a 1013 argument. So it's just that's looking at it perhaps from a slightly different angle, through a different lens. And then I'll move on, if I may, to the VISA Inc. cross-appeal arguments made by Mr. Rabinovitz, which are addressed in section G of the CAT's judgment. VISA is saying, under this ground of cross-appeal, that even though the Court of Appeal and the Supreme Court held that the default MIF rule was a restriction of competition in breach of 1011, VISA escapes the binding effect of that judgment, and none of its MIFs are held to be anti-competitive after the 21st of June 2016, because on that date, VISA Europe was acquired by VISA Inc. And after that date, VISA Inc. set the level of VISA's MIFs. Mr. Rabinowitz's argument turns on the distinction found in Article 1011 between a decision of an association of undertakings on the one hand and agreements or concerted practices on the other. And you may recall that the very early Court of Justice European decisions held that the arrangements between VISA Europe, which were then a group of banks, effectively not an individual company, were decisions between an association of undertakings, because it was a decision to impose MIFs made by the banks collectively, who were members of the VISA Europe scheme.
Yeah.
So that was the basis on which the very way back decisions were made by the European courts.
Yeah.
But Article 1011 does not just prohibit decisions by association of undertakings, it also prohibits agreements or concerted practices. And just for your note, my lord, the actual terms of Article 1011 you haven't been taken to, but they are in the Balmoral Tanks judgment, to which your lordships have been taken. For your note, that's Authorities, Bundle 3, Tab 10, page 962. I don't think I need to take you to it for these purposes, but if you need to refer to it. But I will take you, if I may, to the CAT's judgment on this VISA Inc. point, because we effectively say, in this regard, the tribunal got it right. It's Core Bundle, Tab 5, page 176, and it starts at paragraph 90. And the point is made at the beginning of paragraph 90. It is common ground that VISA Europe is and was at all material times responsible for the rules and operating procedures of the VISA scheme, On the 21st of June 2016, VISA Europe was acquired by VISA Inc. Prior to that acquisition, as I said, it was an association of over 3,000 European banks by whom it was owned. While VISA therefore admits that the setting of the VISA MIFs before VISA Europe was acquired by VISA Inc. were decisions of an association of undertakings, VISA contends that this was no longer the case after 21st June 2016. VISA contends that there was therefore no infringement of Article 1011 in any respect after that date. And in a nutshell, the tribunal's answer to that is, well, there may not have been a decision by an association of undertakings, but there was clearly an agreement or concerted practice. Now, we say the CAT was correct to reach that conclusion, that even if there was no decision of an association of undertakings after June 2016, it's irrelevant.
Just
Because there was an
understand the point
agreement.
that they're making, I mean, I think I do. What they say is you can't, because of the scheme rules to which all the banks are parties, there's an agreement or concerted practice, well, it's an agreement effectively. You don't need to get to concerted practice really.
Yes.
And that remains the case even once VISA Inc. set the MIFs.
Yes, my
Is that
lord,
the point?
that is pretty much it.
Yeah.
Um,
And that's what they say at 95, isn't it?
yes,
So just to understand a moment, I'm sure this doesn't particularly matter. The VISA Inc. sets a set of rules.
sorry, I'm not sure who sets the rules initially, but the rules are, the membership agreements are between the issuers and acquirers and VISA Europe, in the case of the European acquirers and the European
I see.
issuers.
So each party to the scheme, to use possibly a doubtful term, enters into an agreement with VISA Europe, with VISA. They don't agree things between themselves,
No.
but because they have their agreement with VISA, they know that MIFs have to be paid and so on and so forth, because they're parties to the scheme.
And they're all parties to the same scheme rules. And they all enter into, each acquirer and each issuer enters into a license agreement with VISA Europe to abide by the scheme rules, and the scheme rules are public. And the scheme rules, for the purposes of this argument, which has nothing to do with the post-IFR counterfactual, set out not only the obligation to impose MIFs, but the level at which those MIFs will be imposed. And the fact is that within the fact is that remains the case even after VISA Europe was acquired by VISA Inc. And VISA Inc. after acquisition told VISA Europe what the level of the particular MIFs will be. The point that the tribunal makes is the scheme agreements entered into by the issuers and acquirers, as I've explained, which contain the default MIF rule, including both the obligation to charge the MIF and the level of that MIF, continue to be with VISA Europe.
Yeah, because the scheme, so VISA Inc. set the MIF, but the banks, the issuers and acquirers, are bound by the scheme rules with VISA Europe.
Yes.
To apply those MIFs which have been set, albeit that they've been set by VISA Inc.
Yes.
So it's actually irrelevant to the issue as to whether there's an agreement between an agreement or concerted practice that VISA Inc. have become involved at all.
And my lord, as the tribunal says at paragraph 95.
And they go on to deal with the MasterCard position as determined by the CAT and Mr. Justice Popplewell. And they make the point that when it came to the Supreme Court said in terms, well, this was I forget where it is now.
It's on paragraph 99.
99, the setting
Yes.
of the UK MIF was pursuant to an agreement between undertakings within the meaning of Article 1011, and the Supreme Court clearly had in mind that it was the agreement on the part of the acquirers, the issuers and acquirers.
Absolutely, my lord. And the paragraph there, I can take you to it if it assists, but I don't think it says much more than what's set out there in the tribunal's judgment. It's paragraph 42 of the Supreme Court judgment.
Yeah.
Although, to be fair, the Supreme Court it was not an issue. By the time it got to the Supreme Court, this was agreed.
Yeah.
The court did consider the point, refer, as it said there, without disapproval to this fact, and expressly referred to the various first instance judgments that are set out in the court, in the tribunal's judgment of paragraphs 96 and 97.
Can I just clarify one thing? You've emphasised that the agreements are with VISA Europe.
Yeah.
Would it make any difference to your case if VISA Europe had dropped out and VISA Inc. were instead
The only difference it would make is that VISA Inc. is not a defendant to these claims. VISA
Yes, I
Europe is
see,
a defendant
yes.
to these claims.
But it wouldn't make any difference in principle.
The analysis would be the same.
The analysis would be the same. So, Mr. Rabinowitz's arguments of yesterday, I think I can deal with them in 3 brief points. We say they are arguments of form over substance. First, Mr. Rabinowitz stressed that the restriction of competition in this case is found on the acquiring market. That's true. He also stressed, however, that the acquirers do not deal with each other or enter into agreements with each other and do not pay each other. That's also true, but in our submission, not relevant. Mr. Rabinowitz appeared at times to come close to suggesting that because the acquiring market is the market on which the restriction of competition takes place, it's necessary to establish that there are horizontal agreements or arrangements between acquirers. I say he came close because I think he veered away from that argument because it's clearly wrong. It's well established as a matter of competition law that an agreement or practice on one market can lead to anti-competitive effects on another market. And that is precisely the situation that we find in this case, and the Sainsbury's judgments all proceed on that basis. The second point which Mr. Rabinowitz made, which is at day 2, page 83, lines 1 to 9, he argued that the visa arrangements were just a series of vertical agreements akin to airports imposing landing charges on airlines. But that analogy is quite wrong, and we say apt to mislead. If, as he said, Heathrow imposes a landing charge on any airline which wants to use Heathrow's facilities, and it has a set of rules or a standard contract where if you want to land at Heathrow you pay that charge, he says there's a series of vertical agreements. Everyone knows what you're agreeing, you know your competitors are agreeing this and you agree it as well. But that is a misleading analogy for the following reasons. Airports compete to obtain airline customers. If an airport sets its standard terms for prices of landing slots at an uncompetitively high price, demand for its landing slots will decrease because airlines will go to other airports, subject to the regulation of airport landing slots. I'm not even going to get onto that one. But eventually the prices for landing slots will reach a market equilibrium. In the current situation, there are vertical agreements between the schemes, VISA and its issuer and acquirer members, and there are horizontal agreements between issuers and acquirers, pursuant to which the transfers of funds take place. So they go that way and they go that way. There is a transaction between the issuer and acquirer, and as part of that transaction, a MIF is deducted from the value of the funds transferred, and the level of that MIF and the obligation to deduct that MIF is set pursuant to the scheme rules, which the issuer and acquirers have both agreed with the scheme. So we therefore say that Popperwell, Mr. Justice Popperwell, as he then was in paragraph 34 of the AAM judgment cited in paragraph 97 of the tribunal's judgment, his conclusion that the setting of the MIF was pursuant to an agreement between undertakings was a concerted practice is absolutely correct. And the tribunal cannot be said to have got that wrong. Final point, under his ground of cross appeal, Mr. Rabinowitz argued that essential fact number 1, Roman 1, in paragraph 93 of the Supreme Court judgment, which states that the MIF has to be determined by a collective agreement between undertakings, is not fulfilled as regards the VISA Inc. MIFs after the 21st of June 2016, because the level of those MIFs was determined by Visa Inc. alone after that date. And that also is a point made by Mr. Kennelly as regards Visa's inter-regional MIFs at any time, which have always been determined by, the level of those MIFs have always been determined by Visa Inc. alone. And we say that argument is also, Visa's case in this regard is also unarguable, because it's clear that the Supreme Court's reference to the MIF being determined by a collective agreement between undertakings in paragraph 91(1) of the Supreme Court judgment was no more than a reference to the MIF being determined pursuant to these collective arrangements between undertakings. And if I just could take you to the Supreme Court's judgment very briefly to make that point good. Paragraph 19 is at Authorities Bundle 3, tab 13, page 1121. Paragraph 93 is there on that page between F and G. The essential factual basis on which the Court of Justice held there was a restriction on competition is mirrored in these appeals. And then essential fact 1, the MIF is determined by collective agreement between undertakings. And then if you go back to page 1112, you see paragraph 42 under the heading issue 1, the restriction issue. In the CAT proceedings, the CAT decided 2 issues which are no longer in dispute. Those are set out. And then the following paragraph, it is also not in dispute that the setting of the UK MIF was pursuant to an agreement between undertakings within the meaning of Article 1011. And the Supreme Court there explicitly refers to the particular paragraphs of the CAT judgment, the Mr. Justice Popwell's judgment, and then Mr. Justice Phillips' judgment, which are relied upon by the tribunal in this case. So that was the basis of the Supreme Court's essential fact finding in paragraph 91. So, my lord, that's Mr. Rabinowitz's Visa Inc. argument. If I could then move on to the interregionals arguments.
Yeah.
And those consist of my ground 2 of appeal and an aspect of the Visa's cross appeal that was addressed by Mr. Kennelly, but my ground 2 was addressed by both Mr. Kennelly for Visa and Mr. Cook for Visa yesterday. And I'll try to address their submissions together. If you still have the CAT judgment open, that's Authorities Bundle tab 5, Core Bundle tab 5, page 166 is where the relevant section of the judgment starts. In fact, the relevant section of the judgment as a whole starts, I'm afraid, I apologise, on paragraph 163 under the heading Interregional MIFs, Commercial Cars and Italian Domestic MIFs. And then interregionals are dealt with starting at paragraph 61 on page 166. And just to highlight the points of fact that are not disputed, paragraph 61(2), it is not disputed that interregional MIFs have been significantly higher than domestic and EEA MIFs. Paragraph 63, the finding of fact, or the undisputed fact, interregional transactions constitute only a relatively minor part of merchant transactions compared to domestic and intra-EEA transactions. Now, my lord, that statement is at a high level of generality, and in my submission, what the tribunal must be saying there, and clearly is saying there, is that across the board, looked at generally, it's not clear whether it's across the UK or across all the body of claimants, but across the board, interregional transactions constitute a relatively minor part of merchant transactions compared to domestic and intra-EEA. Because, as I believe the Chancellor said yesterday, the proportion of interregional transactions for any particular merchant will be different, because the extent to which, or the proportion of interregional transactions for which any particular merchant receives card payments will differ from merchant to merchant depending on the nature of the merchant. And that leads me to my third very important point, and it is this. Yesterday, the Lord Chancellor drew, or I can't remember who took up the point first, but Mr. Kennelly and the Lord Chancellor discussed the fact that certain of the claimants in these actions are garden
Not
centres.
here.
I'm sorry?
The Lord Chancellor is not here.
I'm so sorry. I am so sorry. I've promoted you prematurely. My lord, I apologise.
Sorry. I couldn't resist.
Oh dear,
teasing
yes,
you
it's
about
been,
that.
it's been a long 3 days.
Yeah. Anyway, either I or
Yes, a discussion took place between the court and Mr. Kennelly about the fact that certain claimants were garden centres, for example. Now, of course, that are unlikely to receive interregional transactions. Of course, where a particular merchant does not receive card payments for interregional transactions, that merchant is not making any claim for damages arising as a result of the inclusion of the interregional MIFs in their MSCs. The damages claimed by the claimants in these cases, in common with all the other interchange fee cases, the damages claimed by the claimants are the MIFs paid by them, the interchange fees paid by them, because that, as the Supreme Court held, is their primary measure of loss.
They don't pay MIFs, they pay MSCs, but you
They
mean
do,
the element of the MSC which
The
is
element
MIF.
of the MSC, which is the MIF, yes. And I'm not going to go into the detailed accounting methods used to calculate that. But as a matter of, by definition, summary judgment in respect of interregional MIFs is not sought by claimants who don't make any claims for that element of the MSC paid, who have not paid interregional MIFs. Summary judgment.
What is the form of judgment that you seek?
Very good
A
question.
declaration.
I think it is, my lord, yes, it is a declaration. I'm going to have to try and dig out where it is. Perhaps I could ask
Well, don't worry now. But
could ask my juniors to dig that out. So, those claimants who have paid if we're looking for the declaration source.
Quickly enough, because it'll either be in the.
I'm not sure.
I'm not sure we've actually got your application. for
No,
summary
I'm not sure we
judgment.
have it. Maybe I need to get a copy of that from the court. Quite understand. We'll see what we can do as quickly as possible. So those merchants who have paid interregional MIFs as part of their MSCs will have paid, and this again is recorded in the CAT judgment, those MIFs, either they will have paid MSCs either by way of a MIF plus MSC or by way of a blended MSC. And I'd like to deal with each of those in turn. The MIF plus MSC is described in the CAT's judgment on page 167, footnote 37 to Dr. Neal's report, which is cited in paragraph 64 of the Tribunal's judgment.
Yep.
I think I took you to that footnote 37, where an MSC for any transaction is set to the sum of the interchange fee, scheme fee, and a fixed acquirer's margin. On day 2, page 128, lines 1 to 8, Mr. Kennelly said, "It is true as a matter of theory, a MIF plus arrangement does create a floor below which the MSC will not go, because it is calculated by reference to the MIF. But whether that is the basis for a finding against the defendants in respect to particular claimants will depend on the evidence of which acquirers and merchants had MIF plus arrangements." Well, that's obviously the case, my lord, but I say that that is effectively a concession that for such claimants, summary judgment should be given. As for a blended...
Just pausing there, supposing that's right, what should the CAT have done about it? What should we do about it?
I will dig it out, but I may be wrong. I don't want to speak out of turn, but I believe what we sought was a declaration. But I will find exactly what the form of that declaration was.
As you say, you better check, but So,
I'm not
Judgment
sure
for
the
liability.
declaration explicitly distinguished between the two
It was a
different types of
judgment for
MIFs.
liability, wasn't it? Because it wasn't purporting to deal with quantum damages at all.
Oh, absolutely
It wasn't
not.
purporting to deal with 101(3) either, so
No,
it can't
exactly.
be a judgment that you are liable. It must be
No,
a judgment that
A declaration that's subject to this, that and the other.
Okay. Yes, there is a summary, and again, we'll see if we can find the application, but there's a summary of in the court, the CAT's judgment of paragraph 23 of the summary judgment that we sought. As you say, it had to be pretty high level because we still had issues of 1013, quantum, etc. But the tribunal summarises it, paragraph 23. We'll see if we can dig out exactly the application.
I mean, it's just for the sake of argument, supposing you were said to be right on MIF plus arrangements, but not on anything else, so that you were entitled to some relief in respect of MIF plus arrangements.
Yes.
How would that play out?
Well, my lord, I believe the relief that was sought was summary judgment that the rules of the MasterCard and Visa payment schemes in respect of interregional MIFs infringed 1011. And so if the tribunal had held that only a particular subset of interregional MIFs infringed Article 1011, then we would have asked for summary judgment in those terms.
But it's not a subset of interregional MIFs.
It's a subset, but, sorry, a subset of interregional MIFs, which is those interregional MIFs which
Where the merchant service charge is calculated
Yes.
as.
But that's a bit odd because the MIF which you're attacking
yes,
is the charge between the issuer and the acquirer. But this subset depends on the way the acquirer structures its merchant
Yes.
service charge, which means you can't identify a subset of MIFs because
It's not a subset of MIFs at all.
it's not a subset of MIFs at all, because the same MIF might, by one acquirer merchant service charge, be done on a MIF plus basis, but the same acquirer with the same issuer and the same MIF might do it on a different basis with a different merchant.
I suppose, my lord, that leads to we say that the rule is what we challenge, the rule, the default MIF rule, which says that you should pay MIFs, including the following MIFs, is what we challenge as being in breach of 1011. That's
then you would say
the
that
restriction.
If the tribunal had been in your favour on MIF plus MSCs, you'd say, well, only a proportion of those MIFs which is the subject of the rule would in fact be in breach of Article 1011. Is that,
Yes.
is that the argument?
What we're saying is that, I'm sorry, maybe I put
Not
the
sure how
things,
that works.
maybe
Yes,
I
I'm
put
not-
it too high. What we're saying is that effectively what Mr. Kennelly conceded is that the MIF plus arrangement does create a flaw.
Yes.
We say, right, so one assumes that MIF plus arrangement creates a flaw. We also say that a blended MIF creates a flaw. And we say that therefore, together, we say therefore, the interregional MIFs also to create a flaw, even though there may only be a small volume of them in, for example, a blended MIF. And that there are two issues: whether they create a flaw under the Supreme Court's judgment of what is the breach of 1011, and the second question is the restriction of competition appreciable, and they're related questions.
But we mustn't lose sight of the fact that the restriction you're attacking is the MIF, not the MSC. The MSC
Oh,
is,
yes, of
the
course.
effect.
It's a consequence.
Yes, the MSC is the consequence. What we're attacking is the default MIF rule generally, which says you must pay acquirer to issuer interchange fees on every transaction.
Yes.
And those interchange fees are set at different levels
Yes.
and for different types of transaction. The interregionals are set very high, but there are quite a small number of them. Actually, we would say that it doesn't matter what level the MIFs are set at, because what is the problem is the rule that obliges you to pay a MIF. The other side say, well, that's not the case, where the impact of the rule that obliges you to pay a MIF is very, 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 very small. And we say, first, you need to look at the impact of the rule, not just by reference to interregional MIFs, because the rule is set generally that you have to pay an interchange fee. And and there are a number of different interchange fees that you have to pay, but the existence of that rule affects competition in the acquiring market. And we say, in any event, the fact...
Is that a submission that you haven't got two rules, you've only got one rule?
We've always said, and our case has always been, that it is the default MIF rule that creates the restriction of competition.
I'm sorry, my lord, I must stand. I mean, that is not the basis on which it was put below. It was the basis on which an appeal was brought in relation to sort of the Italian MIF limitation issues, which was a judgment delivered about 2 years ago, and the decision was made not to appeal that finding. So it's not a point that is now open to say that the general MIF rule is the challenge. That's not how it's proceeded, which is the reason why the CAT's judgment addresses commercial cards differently from Italian cards, and not just says the rule saying you must pay MIFs is intrinsically wrong, because some MIFs may be lawful MIFs.
That's the whole point, isn't it? That's why the tribunal engaged in the analysis they do from paragraph 61 onwards.
Absolutely. Each one's separate and each one's considered separately. So.
Right.
Well, my lord, I hesitate because our pleaded case in it is, and always has been, that it is the obligation to pay an interchange fee in respect of each transaction. That is the restriction on
But what one's
competition.
looking at is the effect of that on different markets.
Well, my lord,
And here one's looking at the inter-regional.
no, my lord, oh, absolutely not. We are looking at the acquiring market as a whole. And our pleading case has always been at the acquiring market, which is where acquirers compete for the business of merchants. And we have always, and that is the relevant market. It is not, there is no, and there never has been any argument that there are separate markets in which acquirers compete for. Well, they couldn't, because merchants don't know what transactions they're going to have to deal with. They know that they are going to have to deal with card payments, and they enter into an agreement with the acquirer to pay a certain MSC, which is calculated either by reference to each of the MIFs they pay plus, or it's paid by reference to the blended average of the MIFs set plus margin, and they compete over the level of that fee. So there's no separate market for processing different types of transactions. In fact, I'm now getting myself into a twist. There is no separate market, but on the acquirer level between acquirers and merchants, whereby acquirers compete for interregional card transactions processed by merchants, because, as I just said, they process all transactions that come into them and present whenever a card is presented to them. So, and that really is the heart of what we're saying, that interregional MIFs are just one of the MIFs that factor as part of the MSC and are taken into account by the acquirers in calculating MSC, and that is why in my opening submissions on this point I took your lordships to paragraph 17 of my skeleton, where we summarised the scheme's pleadings, where they admit that the prices acquirers charge to the merchants through the MSC take into account the MIF at a general level, and we say that clearly, as a matter of, well, by definition, will include, even though it's only a small proportion of interregional MIFs, will include those interregional MIFs. Therefore, the interregional MIFs, as part of the MIF that's taken into account for calculating the MSC, also fall within paragraph 93(6) of the Supreme Court's judgment, because they form part of the minimum price floor.
So can I just see if I understand what you're making? The point is that the setting of the MSC is quite general. In fact, I think we were shown that letter yesterday,
Yes.
which suggests that some of the acquirers actually set MSCs not just for one of these schemes, for both of them, and possibly for other things as well. But it doesn't, in setting the MSC, there's no attempt to say, well, in relation to interregional or things coming from abroad, you will pay X level of MSC. There's just a setting of the MSC and looking at it in broad terms. You either have an MSC that's set as a MIF plus in terms, or a blended MSC that takes account of all the different costs and MIFs for all the different transactions that may be that particular merchant will be passing through to the acquirer.
Yes.
But because, if you like, preponderance of the transactions would be ones where the MSC itself was higher than the MIF, then it doesn't matter that in relation to interregional ones taken in isolation, the MSC is actually lower than the MIF for that particular transaction.
It certainly doesn't.
Is that the point?
It certainly doesn't matter for those transactions where the MSC is higher than the MIF. We say it also doesn't matter where if there are transactions where the MSC is lower than the interregional MIF, because that can happen by definition where the interregional MIF is high, but the proportion of interregional MIFs taken into account in averaging the MIFs for the purposes of a blended MSC is low. It makes no difference. They still, even on an averaging basis, form part of the MIF element of the MSC, which forms a minimum price floor.
But that depends on it being passed on in its entirety, doesn't it? If the submission that it forms
The question of acquire a pass on, as it's become known, that is whether the MSC does pass on all of the MIF charged by the acquirer to the merchant, is a separately pleaded part of the MasterCard's case, and I think now will shortly be a separately pleaded part of Visa's case. But that is a fight that,
Yes.
one of the other fights we will have to have. But the tribunal judgment, as I understand it, and certainly the Court of Appeal and Supreme Court judgment, proceeded on the basis that, and I think this was common ground, that the MIF was passed on by the acquirer to the merchant. And I can find the Supreme Court and Court of Appeal paragraphs where that's recorded, but it is recorded that there was 100% pass on.
I don't recall it the other being the case. Or I don't remember anything other than the
That was,
MIF was always passed on as part of the MSC.
that was certainly the case before the Court of Appeal and the Supreme Court, as is the nature with these interchange proceedings. Points pop up all the time, new points, and this is another new point that has popped up. And I'm not going to pin my colours to the mast as exactly when the pleadings were amended, but they have been amended so as now to make the point that not necessarily 100% acquire a pass on. But we say, proceeding on the basis that was before the CAT, the MIF, yes, the interregional MIFs as part of the MIF, part of the MSC, do form part of the minimum price floor for the purposes of paragraph 93(6) of the Supreme Court's judgment. Moving then on to the point made by Mr. Kennelly in his respondent's notice that the CAT's judgment refusing summary judgment on interregional MIFs should be upheld on different grounds. I can deal with that very briefly, and I don't think I need to take you to the materials, but I'll give you the cross-references. Mr. Kennelly referred in his respondent's notice, which is at Core Bundle 10, page 207, to there being different competitive conditions in, I quote, the acquiring market for interregional MIFs. But he supports that submission. In oral submissions, he supported it by reference to paragraph 44 first of Mr. Holt's first expert report. And I do think it's necessary just to take you back to that to make this point, which is at Supplemental Bundle 1, page 315. Supplemental Bundle 1, right, tab number
16.
thank you, before me, 315. Paragraph 44 of Mr. Holt's evidence, expert report. It's quite clear from that section of his report that what he's talking about is competition in the inter-system market between Visa and MasterCard and entities such as, you see listed there, China, Union Pay, Japan Credit Bureau, etc., etc. So this evidence refers to competitive dynamics on the inter-systems market, not competition on the acquiring market, which is the only market relevant for the purposes of Article 101(1). The same point can be made about Mr. Holt's third expert report, paragraph 22, to which Mr. Kennelly also referred, which talks about the impact of interregional cardholders moving to Amex rather than staying with Visa or MasterCard. So it's again about impact on competition on the inter-systems market between Amex and Visa and MasterCard. For your reference, that's Supplementary Bundle 1, tab 17, page 328. The only other point addressed by Mr. Kennelly were his separate arguments on Visa Inc. alone, setting the level of interregional MIFs at all times, not just since 2016. But I do think that I've already effectively addressed by that, yes.
What you said about Visa Inc.
Yes, that's addressed for your note in section H of the CAT's judgment below, and we adopt the reasoning in those paragraphs 104 to 118. Then I need to address Mr. Cook's respondent's notice, where he argued that the CAT's judgment refusing summary judgment on interregional MIFs should be upheld on yet further different grounds, those being that interregional interchange fees are an ancillary restraint, and that is argued in his respondent's notice at Core Bundle, tab 9, page 196. Now you may recall yesterday, my lord, the Chancellor asking Mr. Cook what was the feature which distinguished the situation regarding interregional interchange fees from the previous court judgments on ancillary restraint. And he answered at transcript reference day 2, page 196, lines 5 to 17. And he said, the number of players, other players out there, as I said before, when one is talking about interregional, where we are talking about interregional MIFs resulting in MSCs in the UK, we are talking about a product that is being offered to Japanese cardholders, Chinese cardholders, Australians, Americans, all those kind of categories. And in those circumstances, one does face a much greater range of competitors than one does in the UK market. And also in the context of that kind of interregional international business, even players like Amex that do feature in the domestic market are much bigger players. They have a much more substantial market share, so they are more of a threat. So the greater range of competitors that one faces are competitors such as Amex, and it's the competition between MasterCard and Amex at the inter-systems level that Mr. Cook says distinguishes the position in regards inter-regional MIFs. So just like Mr. Kennelly, Mr. Cook in my submission is not talking about competition on the acquiring market, but instead about competition to MasterCard on the inter-systems market from undertakings such as China UnionPay and Amex. So, my Lord, I would say that I do submit that the Court of Appeal's findings on ancillary relief in the Sainsbury's judgment apply equally to both Mr. Kennelly's and Mr. Cook's cases. Mr. Cook is the only one who's making an ancillary relief argument. The Court of
restraint.
Yes, ancillary restraint. It was late when I wrote this bit. If I could just finally take you then to the Court of Appeal's findings on ancillary restraint. It's Authorities Bundle 3, tab 12, page 1048. Paragraphs 198 to 200. So you see on page 1048, just above that, paragraph 198, discussion and conclusion on the death spiral issue. Then you'll see what this issue is in the introductory sentence, first sentence of paragraph 198. And I quote, on this issue, we will apply the legal principles applicable to the ancillary restraint doctrine as set out in part 4 of this judgment. On that basis, Roth J was wrong, we have said, to conclude that the issue of whether, in the absence of the default MIF, the MasterCard scheme would survive in view of the competition from VISA was one which could be considered under the ancillary restraint doctrine under Article 1011. Such questions relating to the application of the so-called asymmetric counterfactual, which is competition between VISA and MasterCard, are not for the ancillary restraint issue under 1011, but for the issue of exemption under 1013. Can I ask you to read to yourselves paragraphs 199 and 200? And my submission is that if, in paragraph 198, you substituted China UnionPay or Amex for VISA, the reasoning would equally apply. And on that basis, Mr. Cook's arguments on ancillary restraints in this context, the interregional MIFs, inevitably have to fail. Now, you may recall that yesterday, towards the end of the day, Lord Justice Nugee suggested to Mr. Cook, when he was making his arguments on ancillary restraints in this context, that his arguments were just a variant of the death spiral argument for interregional transactions. And in response, in that discussion, the Chancellor commented, although I think the transcript records this as having been said by Lord Justice Nugee, as I recall it was the Chancellor, that the comment was made that the reason why the death spiral was held to have failed in the Court of Appeal's judgment in Sainsbury's because Visa's scheme was also unlawful. Now that point does appear, my lord, in paragraph 204 of the judgment.
Yeah.
But with respect, in my submission, the primary reason for the Court of Appeal's dismissal of MasterCard's ancillary restraints argument in this judgment is that set out in paragraphs 198 to 200. What follows was strictly obiter, because if you see in paragraph 201, you see at the beginning of paragraph 201, even if Popwell J had been correct in his conclusion, etc., we would hold that the ancillary restraints doctrine doesn't apply. But the Court of Appeal has already held, for the reasons set out in 198 to 200, that the ancillary restraint doctrine does not apply because it refers to competition on inter-system market rather than on the acquiring market, and those questions are for the issue of exemption under Article 1013, as is said under the end of paragraph 198. Before I sit down, I have two references for your lordships. The reference to acquire a pass on of the MIF, that is that the MIF accounts is passed on through the MSC in the Supreme Court judgment is found at paragraph 10, subparagraph Roman 10. Which is page 1107 of Authorities Bundle 3, tab 13. I've been given the wording of the draft order that we sought for summary judgment. I can read it into the transcript, but I think it's probably better that I produce the application itself.
I think if you could produce the application notice, that would help.
Thank you. Unless your lordships have any further questions, those are my submissions in reply.
Thank you very much, Ms. Smith. Now, who's got a right
think
to
it's
further
me.
reply?
My lord, yes. And I'm just going to be replying on the Visa Inc. point.
Sorry, replying on what?
Just the Visa Inc. points. In other
Okay,
words,
yeah.
I think that's the only thing. We obviously have a reply on the Visa Inc. point and the inter-regional Visa Inc. point.
Yeah.
Can I begin just by getting something out the way? I'm going to be very short. You'll be pleased to hear. My learned friend made a point at some point, right at the beginning, about Visa Europe. I wasn't sure where the point went, and I'm not sure my learned friend thought the point went anywhere because she said her submission would be the same in any event. But just to be clear, following June 2016, because maybe your lordships are not clear about this, Visa Europe was no more than a subsidiary of Visa Inc. It doesn't go anywhere, and I don't need to say any more about it.
No.
A second point, which I need to be very clear about, is this. Although my learned friend presented my argument as in some way turning on or depending upon a distinction between agreements, between associations and undertakings, or simply agreements, and concerted practices, with respect, that is simply not the case. As your lordships will recall, I made it expressly clear that whilst the tribunal had formed the view that if there wasn't an agreement between associations of undertakings, it considered there was nonetheless a concerted practice. I made it clear to your lordships, as we do in our skeleton, that although we don't agree with that, for the purposes of the argument before this court, I proceeded on the basis that that was correct. My argument, which with respect to my learned friend did not address, at all was as to whether the tribunal had failed to address an argument that we'd made to it. And the argument, as your lordships will recall, was this. The tribunal itself concludes, this is at paragraph 93 of its judgment, I'll take you back to it, that following 21st of June 2006, it is at least arguable, possibly more, but at least arguable, that VISA Inc. alone set or determined the level of the MIFs. Now, I don't know that there is a difference between setting the MIFs and setting the level of the MIFs. But in our respectful submission, what the tribunal proceeded upon was the basis that from the point in time where VISA Inc. alone was in charge of deciding the content of the rules, and indeed the level of the MIFs, VISA Inc. alone set the MIFs. Now, why does that matter? With respect, it matters because my learned friend wants to say that we are bound what the Supreme Court said in the first wave case, in the Sainsbury case. But as I'm going to show you, Lordship, and I have time for this, the explicit basis upon which the Supreme Court found there had been a restriction of competition was because there had been collectively determination, collective setting of the MIFs. An association of undertaking gets together and they set the MIFs. They set the amounts that are going to be paid as between them. And that, one can see, the Supreme Court has said, was a restriction of competition which produced a competitive vice. Now, if I show your lordships paragraph 93 of the tribunal's judgment, so that's core 5, page 177. My learned friend showed you paragraph 90. Perhaps just look at that again. VISA therefore admits that the setting of VISA MIFs before VISA Europe was acquired by VISA Inc. were decisions of an association undertakings. VISA contends this is no longer the case after 21st of June. So that's what we were saying, paragraph 90. Paragraph 93, the tribunal says this. We accept that it is well arguable on the basis of the facts set out in VISA's evidence and summarized in its skeleton argument that since the 21st of June 2016, VISA Europe has no longer been an association of undertakings. Further, we acknowledge that decisions as to the level of MIFs thereafter have been taken by VISA Inc. And then the tribunal says, but that does not dispose of the claimant's pleaded alternative bases of claim of that the implementation and maintenance of the MIFs constituted an agreement, etc. So the focus, as I say, is not on the setting of MIFs, it's on implementation and maintenance of MIFs. The Supreme Court case decision was predicated upon a setting of MIFs. And can I very quickly show your lordship, just remind your lordship of that, your lordships of that. You've seen this before. Just 3 short paragraphs, 2 of which my learned friend actually took you to. If you go back to Authority 3, tab 13, beginning at page 1121. Again, it's the 6 facts, but fact number 1, the MIF is determined by collective agreement. And then 3, the non-negotiable element of the MSC is set by collective agreement. Now, my learned friend took you helpfully to paragraph 42, which is at page 1112. If we just go back to that. In the CAT proceedings, the CAT decided 2 issues which are no longer an issue, namely that 1, the MIF did not amount to restriction of competition by object, and 2, restriction issue felt to be considered against the counterfactual in which the transactions would be settled at par by default, which was equivalent to a default of 0. It is also not in dispute that the setting of the UK MIFs was pursuant to an agreement between undertakings. So again, setting of the MIFs. And again, if I can, I'm sorry to jump around like this, but if we go back to, again, some paragraphs we looked at before, at page 1122, I think my learned friend has shown you paragraph 99 before. On the facts as found, the effect of the collective agreement to set the MIF, again, setting the MIF. And then paragraph 101, while it is correct that higher prices resulting from a MIF do not themselves mean there is restriction on competition. It is different where such higher prices result from a collective agreement. Again, that is the setting of the MIF. Now, as your Lordship see from paragraph 93, it's at least arguable. I need to put it no higher than that. On the 21st of June 2016, the setting of the MIFs was not by collective agreement, nor indeed could it be said that it was by collusive practice, whatever it is. It was done by VISA Inc. alone, and the tribunal accepts that as a possibility.
Just to be clear, I mean, in a sense, the vice is not the level of the myth,
No.
it's the existence of the myth.
Okay,
I mean, Visa Inc. sets the rules, and I dare say that they set the rule that
that there
provides
should be a
for
MIF.
the existence of a myth.
Exactly.
But then everybody signs up to that.
Okay, that's correct. They do sign up to it. In the same way as if an airport sets a price for landing and it has a series of vertical agreements, everyone does sign up to it. You have the same competitive, I'm going to call it a competitive vice, which arises. Take Amazon as another example. Anyone who wants to sell on Amazon enters into a vertical agreement, not a horizontal agreement, but a vertical agreement, whereby they agree to pay the price that Amazon charges in order to sell on Amazon. It sets a platform, a floor, which is then passed on to by the merchant to the consumer.
But it does look different because everyone is signing up to a club, a set of rules, under which they will do things as between themselves. It's not
With
just that they will
respect-
pay the airport, they will deal as between themselves.
Well, your Lordship says do things as between themselves, and yes, in that general sense, that is correct. The people in the same market do not do anything as between themselves. The acquirers do not do anything, they do not pay anything between themselves, they do not have any arrangement between themselves. The issuers do not do anything.
The visa scheme is between VISA Europe and the issuers.
Well, I think the acquirers are also part of
And
the
the
visa
acquirers.
scheme. Yeah.
So
But there
they're
is
all
no,
part of the scheme.
but no one is agreeing to do anything between themselves. They're agreeing with Visa Inc. that they'll act in particular ways.
But then what then happens is that there are then horizontal agreements between the issuers and the acquirers which apply those rules.
With respect, they're not horizontal agreements. They are vertical agreements because the issuers are higher up in the chain. They are agreements, but they are vertical.
Never mind which direction they're going. There are agreements between issuers and acquirers
They are.
which
They are.
apply those rules.
They are.
And you don't have anything like that in your airport.
With respect, your Lordship is completely correct. You don't have anything like that because you simply have payments from the airlines to the airport. The question is, why does that matter? Why does that matter? Now, I'm not saying, let's just be clear about this.
Because
I don't have to say I'm definitely right about this. I don't have
what
to say.
they're doing. They're doing pursuant to an agreement or a concerted practice contained in the rules. Never mind who
But what's
sets the myth, but they then apply the rules.
But your Lordship is now moving on something, your Lordship says, never mind
Well,
who's setting the myth.
Yeah, I mean, I follow
I
your
mind
points about
who's
it's
setting the myth.
arguable, and you may be right on that. And if you're right on that, well, then this will all have to be debated and tried. Maybe what I'm identifying is where the fallacy in your argument lies.
Well, where perhaps the fallacy is. But your Lordship says, never mind who sets the myths. With respect, the only thing the Supreme Court has said matters at this stage is the setting of the myths. Now, it may well be that there is something else. Malone and Friends rely on implementation and maintenance. With respect, I could say the same about Amazon. We always, and the airports, for example. So one does get to a position where the question is, does it matter that people are not in the same market, because they're not in the same market, acquirers and issuers are not in the same market, are making payments to each other rather than to the airport?
I mean, I'm going to produce something that obviously is not a true analogy, but suppose you have lots of manufacturers of widgets and somebody tells them the price should be such and such, and they all agree that with the person at the top, and they then act on the basis that the price is so and so. I mean, they can't just say, oh well, we only agreed it with the person at the top.
Why, with respect, why is that different to the airport example? The airport actually tells them this is what you're going to pay, and they all agree to pay it. And the consequence of that is you set a floor, a platform, below which a price charged to a user of an aeroplane, I think they call passengers, will not drop. Why is that different to the Amazon example? Amazon are actually telling you this is the price you're going to pay.
To pay to the airport. I'm taking it a stage further because I'm assuming the widget manufacturers are told what to charge their customers.
Well, part of the price.
Usually
So an airport says part of the price you're going to have to charge. Doesn't say part of the price you're going to have to, because you don't have to. Part of the price you're going to have to think about charging is the fact that there's an airport landing charge. Sorry, I'm being told the correct answer behind. If the airlines are told what price to charge downstream, then that is a resale price maintenance problem and gets dealt with in a different way. Not
Yeah,
under
I was going to
Article
say, I think we're getting into
Yes.
quite a complicated area
But
where
the
there may
point
be all
is-
sorts of other.
No, indeed, but with respect, that is my submission.
Well, I follow.
Because if it's not covered by the Supreme Court, we can argue this out unless someone's going to tell me my argument is in fact unarguably wrong. But with respect, the tribunal didn't explain why, and nor did my learned friend. I mean, that, in a sense, is all I was going to say. I just want to check my notes that that really is all I was going to say. Yeah, I think I just need to make two other points.
Well,
Does your lordship want to come back
I would
after
prefer to
lunch?
sit on until we finish, Vicky.
I'm very happy to do that.
Between you, you think you're going to be more than another 10 minutes.
I would.
My lord, I'm afraid I think I also have a right to reply on the objective necessity point, because that was my
How long do you think you're
argument.
going to be?
I think that's going to be more like 15 or 20 minutes, my
Oh,
lord,
well, in
because
case
that does
we-
involve going back to the Court of Appeal judgment in a bit more detail.
In which case, we better break for lunch.
Sorry.
I'm sorry, my lord, if I could do it more quickly, I would,
No,
but it's,
I would have taken the slow.
The case was originally down for 3 days, and you've managed to do it in slightly over 2.5, so we won't complain too bitterly.
Your lordships want to carry on and finish, and then we all.
No, I think we'll run.
Really 5 minutes.
5 past 2 then, please.
All rise.